Hello, Madam Bella. So today, Group 1 will be presenting on Chapter 10 of Land Law 2, which is Strata Titles. So there are four members in our group, which is me, myself, KIRUTHIKA, SYAFIQAH, NADHIRAH, ELISHA, CASSANDRA, and also EVIANA. So SYAFIQAH, NADHIRAH will proceed with the introduction first.
Assalamualaikum and hi madam, my name is SYAFIQAH Nadhirah, BINTI. So I will presenting on the overview what is the strata titles in Malaysia. So basically, the strata titles is often called as the title in the sky because they govern ownership of the space in the multi-story building like condominium, apartment, or any commercial complex. And it's unlike the traditional lantai, which is the traditional lantais define the ownership based on the land boundaries, while the strata titles is focused on the cubic space within a building. So, what is the nature of the strata titles? So, first is issued by the registrar of the titles or land administrator. Second, the titles issued by the unapproved individual are considered fraudulent because only the owner can have it. And third is the titles do not give the holder or potential purchaser a good title, are not marketable, and have no legality and have no legal validity. So this is true even if the purchaser paid a reasonable price and act reasonably, and the owner are not subject to obligation imposed by the strata titles, such as maintaining the common area like swimming pool, spa, and so on. So this is the strata ownership is different from the regular landowner because due to the collaboration aspect, which is a necessity, a group approach to the property administration. So next is why Malaysia needs the strata titles, because nowadays land was very expensive. So the strata is basically an affordable, that can be said. Second is to encourage the real estate investment by providing the define the ownership right. So basically, in the strata titles, the ownership in the multi-unit building can be frequently be complicated because of the common area and the amenities itself, because they share together. So the strata titles give a clear ownership to them. Without the presence of the strata titles, the owner could encounter the difficult attempting to transfer their unit, since the owner border would not be clearly defined. Lastly is the market stability. So since the condominium can be said is affordable, so it was attract the investor and also protect the consumer right by having a good maintenance and obligation and standard for the property development. For example, like maintenance costs, the common area use, and also the other significant property feature in the strata titles. So I will continue next. So next is law governing in Malaysia. So basically, the strata titles in Malaysia are governed by the strata titles 1985. While this act only applies to the Peninsular Malaysia, and Sabah Sarawak have its own regulation. For example, in Sabah have the land subsidiary titles amendment 1972, while in Sarawak have the strata titles ordinance 1974. The National Land Court NLC 1965 also complains the STA, and it's ensure the land's use category and implied condition are met together. However, in the case of the conflict, the STA can take the precedence. Okay, moving on to the weaknesses of the STA. So basically, despite of it being a fake, it also have the own weaknesses. First is limited provision, because it only have one section which is section 85. So it made difficult and insufficient for the complex dispute or any conflict over the shared property or maintenance over the strata titles. Second is no rules for party walls, which is the Act does not address the share walls that can be lead to the potential conflict between Party A and also Party B. And third is the reliance on the common law. And last one is the strata titles is depend on the expert, because they need the expert opinion for the incomplete treatment, such as like a problem that arise. They need someone that expert in some area. So without an expert person, the problem cannot be solved. Last but not least is the application of the NLC in STA. So basically, the STA and NLC is interconnected. Based on the section 5 of the NLC define that the restriction on registration property, consent transfer, lease, or any dealing with their land, although the NLC is initially governed multi-store building subdivision, this provision were repealed by the STA, and however, the certain NLC provision like the land categories stay can be applied unless it was overridden by the STA. For example, in the section 76, Clause D was mandated that the state authority was specified there got 3 categories of land. First is agriculture, second is building, and last one is industrial. So moving on to the next is the application of moving on to the next is the implied condition, which is this one can be referred to the section 114 to 119 of the NLC, which is automatically applied to the land category use. For example, for the agriculture land cannot be used for construction, industrial purpose without the explicit permission, while the building land must be complete with the construction requirement. And last one is the industrial land must be adhere to the regulation for development and also environmental standard. So that's all from me. I will pass to my friends.
Hello, Madam Bella. My name is ELISHA Cassandra. Today I will be presenting on the application for submission of buildings. So first, building must be constructed on alienated land with a final or qualified title as per Section 6 of the STA. An amendment in 1996 has extended the eligibility to buildings on qualified titles, provided that they are surveyed and certified by the Director of Survey. Application must be submitted within 6 months of building completion, and if any parcels that is within the building is sold or agreed to be sold, application must be made. Non-compliance with this requirement can result in penalty of 5,000 ringgit and also an additional 1,000 ringgit per day. The Director of Land and Mines can grant a one-time extension for the submission. In the case of Lee Waikin against Yulek Sendrian Berhad 1986 and also Syed Asman bin Syed Muhammad against Lian Seng Construction Co. Sendrian Berhad 1992, affirmed that the landowner has the duty to submit subdivision application. For the submission of application, there are 4 stages. The first stage is application fee. Completion of prescribed fees is required. The next is proposed strata plan, the details of building location, parcel layout, and also other technical details. And the third one is professional certification, certificate from a licensed land surveyor and also registered architect confirming that compliance with approved plans and legal boundaries. And lastly is the consent and compliance, a written consent from registered interest holders proving that application follows the law, there is no outstanding land revenue, and also equitable shares unit for parcel proprietors. Next one is the approval process and issuance of strata titles. So there are 3 processes. First, the land administrator will complete any necessary documents. Next, the director of survey will prepare certified strata plan. And then approval is granted if condition in section 9 and 10 clause 1 of the STA are met. And lastly, the Director of Survey will finalize strata plan and enables issuance of individual strata titles. So for the issuance of strata titles, titles are recorded in the strata register under section 15 of the STA, and issuance of titles formalizes parcel ownership and allows legal rights. Either they can sell or yeah. Although there are well-structured legal framework, there are still problems in the application and also process. So first is building invasion into the adjacent properties or public spaces requires an additional approvals. And then modification to buildings post initial approval plans prolong the process. For this slide, understanding parcels and common property in subdivided buildings. So first, a parcel refers to one unit within a subdivided building. For example, an apartment, studio, office, or shop lot. A separate strata title is assigned for each parcel. So the owner has the full legal rights and obligation. Meanwhile, accessory parcels are supplementary for units such as parking spaces or storage areas, which cannot be sold or owned independently. It is clearly defined in the strata plan as integral to the ownership structure. Next one is the common property. Common property is an area within the building that is not part of the parcel, which are hallways, elevators, swimming pools, and gardens. These are owned by all parcel proprietors and managed by the management corporation. Common property is a shared use and benefits all owners. So in the case of Golden Connection SB against CSH Enterprise Sendirian Berhad, 1953, 3 MLJ 731, the High Court held that it was common property as the void on the level of mezzanine floor was capable of being used in connection with the enjoyment of more than one parcel, meaning that it is a common property. So that's all from me.
Thank you, Elisha. So, madam, I'll be presenting on the strata title management, formation of the management corporation, legal capacity of the management corporation, and also the duty to maintain the common property and also the council of management corporation. So, what is strata title management? It is very important part of Malaysian property law. It's solely focused on the management and governance of multi-unit properties such as apartments and also condominiums. The main purpose is to ensure the common areas are well maintained, property standards are upheld, and also the collective interests of property owners are protected. So this management is very important in urban areas with high population density, where shared spaces like this need proper oversight to function properly. So let us look at the formation of MC, the Management Corporation. So the Management Corporation is created under Section 39 of the Strata Titles Act (STA) when the strata register for a subdivided building is open. So the MC was introduced to meet the growing need for efficient management of shared spaces in multi-unit developments, especially as the urbanization increased. So the MC represents all property owners, including the parcel proprietors and provisional block owners, to ensure fair and inclusive governance. So their main duties, the MC's main duties include maintaining shared areas, enforcing bylaws, resolving disputes, and also ensuring fair cost sharing among owners. The MC operates independently of the Companies Act 1965 and the Societies Act 1966. This makes it a unique statutory body that focuses solely on strata management and the specific challenges of managing shared property. Next, let us look at the legal capacity of management corporation. The management corporation, they have a legal standing, which means they can take or face legal action in their own name. Its authority covers contract disputes, damage to the property, wrongful use of the common property, and also other issues. So the management properties, they can file cases under civil or criminal law to recover the properties, to claim damages, and enforce it by the laws. So I have an example here. So the example of MC's legal capacity, it can be seen in one of the case, which is RSP Architects Planners and Engineers against Ocean Front Private Limited, 1996. So in this case, the MC successfully sued the developer for poor construction of common property, even without a direct contractual relationship. So the court held that the developer owed a duty of care to the MC, showing how the MC can act to protect the shared property's interest even in challenging legal scenarios. Moving on to the duty to maintain common property. So this management corporation, they are responsible for maintaining and repairing common property to ensure it remains safe and also functional for the residents and also visitors. This involves conducting regular inspection and also addressing maintenance issues on time. If the management corporation, they fail to do their jobs, like the one I mentioned before, they can face legal consequences. So this can be seen in a case of Body Corporate Strata Plan number 4304 against Albion Insurance, 1982. The management corporation, they were held liable for injuries caused by inadequate maintenance of shared areas. They poorly managed the apartment or condominium. Similarly, in another case of Black against Body Corporate, the management corporation was found responsible for injuries caused by a defective handrail. It failed to repair despite being aware of the hazard. So these both cases highlight the importance of MC's role in ensuring safety and also proper upkeep of shared spaces. Last one would be the council of the management corporation. The management corporation, they operate through a council elected by the property owners. So this council is responsible for carrying out the MC's duties, managing its operations, and also making decisions on behalf of the property owners. The council's responsibilities include implementing policies, managing finances, ensuring compliances with legal obligations, and also making key decisions like entering into agreements, organizing repairs, and also pursuing legal actions when necessary. So this council, they act as a decision making body, and they also ensure transparency, accountability, and also efficiency in managing the MC's affairs. So this council, they must act in the collective interest of all property owners while ensuring the smooth operations.
Hi and good evening. My name is EVIANA RICHELLE, and today I'll be explaining about the duties and powers of management corporations, or MC. So first is the duties of MC. The management corporation, or MC, has various duties outlined under sections 43 clause 1 of the Strata Titles Act, STA. and the first and the first duties is maintenance and repair, where the MC is responsible for managing and properly maintaining the common property, ensuring it is in a good and serviceable conditions. This include addressing repairs, upgrades, and preservations of shared spaces to maintain their usability and safety for all parcel proprietors. Second is insurance responsibility, where MC must insure the subdivided building to its full replacement value against fire and other risks prescribed under the STA. Besides it, they also have tasked with affecting additional insurance required by law or directed by special resolutions from proprietors, which to ensure the comprehensive coverage against risks that may jeopardize the building's integrity. That is the applications for an insurance fund. So, in the event of damage to the building, the MC is required to apply insurance money received for rebuilding and reinstating the property. This process is subject to under sections 56 of the STA to ensuring the lawful applications of fund. Furthermore, they also have to pay insurance premium. Ne- Next is the abatement of nuisance and compliance with order. So the MC must address any notice or order issued by competent public or authorities for the abatement of nuisance or necessary repairs to common property or any building or other improvements on the lot. So, and it must comply with such notices or order made in respect of parcel if the proprietor failed to act within a reasonable time frame. And last but not least is administrative duties, whereby the MC is tasked with preparing and maintaining a strata roll for the building, paying rent for the lot, and also ensuring statutory responsibility are met. So there are two examples of case law here. First is in the case of proprietors of strata plan number 6522 against Fernie 1976, 1 and SWLR 412 highlight the broad scope of these duties. For instance, repair may extend to making the property waterproof or renewing defective features. Next case is in Jacqueline and others against proprietors of strata plan number 2795 1975 1 and SWLR 15, which in this case it emphasized that the MC cannot abdicate or diminish its responsibilities for the administrations and maintenance of any part of common property. However, when common property is granted exclusively to a proprietor through agreement or by law, the MC's obligations to maintain and repair that portions may be waived. And as we can see in the Jacqueline case, the interpretations of the grant terms significantly influence the extent of the MC's responsibilities. Next, we move on to the powers of MC. So, the powers conferred upon the MC enable it to fulfill its duty effectively. And the powers of MC has been stated in sections 43 clause 2 of STA, which is first is cost recovery, where the MC has the authority to recover the expenses incurred in complying with notices or orders directly related to a proprietor's parcel, which to ensure the equitable financial responsibility among parcel proprietors. Besides, they also have the power of property acquisitions and borrowing, where the MC can acquire movable property for the use and enjoyment of proprietors and borrow money to meet its obligations. Um, However, to secure the loan, the MC may negotiate repayment using contributions from proprietors or charges on vested property. Furthermore, they also have the power of collections of contributions, which during the initial period, the MC can collect contributions proportionally based on the share units of respective parcels, which to ensure a fair distributions of financial obligation for the management and maintenance of common property. Next is the duties and powers of proprietors before the establishments of MC. So, according to Section 61, Clause 1 of STA, before the establishment of MC, the original proprietor is responsible to control, manage, administer, and keep the common property in good repair and to pay rent of the lot. Next, the proprietor also has to ensure the building to its replacement value against fire and to keep it so insured and to effect such other insurance policies of the buildings as may be required by law. Other than that, subject to any court order, to apply insurance money received by it in respect of damage of the building, in rebuilding and reinstating the building, so far as it may be lawful to do so, and to pay the premiums on any policy of insurance affected by it. Next is Section 61, Clause 2 of the STA also stated that the original proprietor may purchase, hire, or acquire movable property for use by proprietors in connections with their enjoyment of the common property and can do all things that are necessary for the discharge of its duty. Next is the last part of this presentation is Strata Titles Board, which has been stated under Section 67A of STA that there shall be a Strata Titles Board which consists of a president and such member of deputy presidents and other members which will be appointed by the state authority. So, this board is established to handle disputes between the MC and parcel proprietors and also between the MC and other parties. It also stated that no person can be appointed as the president or a deputy president of the board unless he is a qualified person within the meaning of the Legal Professions Act 1976, Act 166, and not more than 20 person shall be appointed by the state authority to be members of the board, in addition to the presidents and the deputy presidents of the board. Last but not least, all the names of the presidents, deputy presidents, and members appointed under this section shall be notified in the State Gazette. So that's all from us. Thank you.